The next lesson, the third lesson in the ABCs of security, we will discuss the legal powers and limitations of a security agent. Lesson 3, legal powers and limitations. Task, react to criminal suspects in ways that will not hamstring subsequent prosecution. Help agents and the company avoid liability. Conditions. Given relevant passages of the Oregon and Washington laws affecting the activity of private security personnel. Standard. Demonstrate understanding and utilization of each of the following. Arrest and detention. Use of force. Search and seizure. Interrogation. In most states, security agents have no greater authority than do private citizens. And, despite the uniform, badge, and so forth, they are not police officers. Citizens have always had the right to arrest for felonies committed in their presence, if based on probable cause. However, some states require 100% certainty for a citizen's arrest. General rule is, a security agent may only arrest someone without a warrant when the offense has been committed in his or her presence, within his or her view, if the offense is a felony or an offense against public peace. A felony is any crime punishable by death or confinement for more than a year. Let's take a look at some felonies. Theft. Theft is the physical removal of an object that is capable of being stolen without the consent of the owner and with the intention of depriving the owner of it permanently. Robbery, on the other hand, is a violent theft of property or money. Burglary is defined as the unlawful entry into almost any structure with intent to commit a crime inside. Arson is the crime of willfully and deliberately setting fire to or charring property. Although the act of arson typically involves buildings, the term can also refer to intentional burning of other things, such as motor vehicles, watercraft, or forests. An assault is the act of illegally committing physical harm or unwanted physical contact upon a person or, in some specific legal definitions, a threat or attempt to commit such an action. It is both a crime and a tort, therefore may result in criminal prosecution and civil liability, or both. Sabotage is a deliberate action aimed at weakening a polity, effort, or organization through subversion, obstruction, disruption, or destruction. Anyone who engages in sabotage is a saboteur. Espionage, spying, or intelligence gathering is the act of obtaining secret or confidential information. The person who commits espionage is called an espionage agent or a spy. Any individual or spy ring in the service of a government, company, criminal organization, or independent operation can commit espionage. Murder is the unlawful killing of another human without justification or valid excuse, especially the unlawful killing of another human with malice aforethought. This state of mind may, depending on the jurisdiction, distinguish murder from other forms of unlawful homicide, such as manslaughter. Manslaughter is a common legal term for homicide considered by law less culpable than murder. The definition of manslaughter differs among legal jurisdictions. Oregon has two divisions of manslaughter. ORS 163.116 describes manslaughter in the first degree, which is a Class A felony, and ORS 163.125 describes manslaughter in the second degree, a Class B felony. Agents must exercise judgment and care in performing arrest functions. Otherwise, legal action may successfully be brought against their employers. In some instances, it may even be brought against the agents themselves. Four types of activity that sometimes involve security agents are important to this lesson. They are arrest and detention, use of force, search and seizure, interrogation. Arrest is the taking of a person into official custody in order to have them answer to a criminal charge. Detention is the brief temporary stop of a person for the purpose of carrying out an investigation. To arrest another person is to restrain that person's freedom of movement. Detention is different from arrest, as we said. It too is a restraint of the person's freedom, but it may or may not lead to turning the person over to police. In some cases, the security department may satisfy itself that the detained person has not committed the crime he or she is suspected of, and will then release the person. Unless the department has very plausible grounds for suspecting the person, it could be held liable for unlawful detention. What is arrest? Arthur C. Weinstock Jr., in his book Criminal Law Procedure for Private Security, defines arrest as taking into custody or restraining the freedom of movement of another person in order to bring that person before a court to answer a criminal charge. Oregon further defined arrest thusly: to a place or person under actual or constructive restraint, or to take a person into custody for the purpose of charging that person with an offense. A stop is authorized under ORS 131.605. To 131.625. A frisk of a stopped person is not an arrest. Washington's version is similar. It says an arrest is lawful if made pursuant to an arrest warrant. An arrest is also lawful if the arresting officer had probable cause to believe that the person arrested had committed the crime of whatever the name of the crime in the officer's presence. To be complete, an arrest should have intent to make an arrest, communication of the intent to the person being arrested, submission by the arrestee, or restraint imposed by the arrestor. This restraint may be physical, as in putting a hand on the shoulder, grasping the arm, holding the collar or belt, applying handcuffs, or it may be restrained by implied or actual threat, as in the tone of voice, language, brandishing a baton. For example, if a security agent taps someone on the shoulder and says, "Excuse me, could we go to the security office? I'd like to talk with you in private," and the person voluntarily complies, that is not an arrest. On the other hand, if the agent says, "I think you stole those items, come to the security office with me, I'm calling the police and turning you over to them," then an arrest has been made. When a security agent makes an arrest, it is what is known as a citizen or citizen's arrest. An arrest made by someone with no specifically conferred law enforcement powers. When to arrest. The legal risks that hover over any arrest may be made by a security agent are staggering. A poorly handled, improper, or illegal arrest can lead to a wide range of civil damage suits, including false arrest and unlawful restraint. If a person is illegally arrested in view of a large number of witnesses and subsequently cleared, a suit for slander or defamation of character may result. Private citizens, security agents in this case, are authorized to arrest another person in any of the following circumstances. If the person has committed a misdemeanor, a relatively minor crime such as shoplifting, petty theft, vandalism, and the agent saw the person do it, as Oregon Revised Statute ORS 133.225 states, a private person may arrest another person for any crime committed in the presence of the private person if the private person has probable cause to believe the arrested person committed the crime. The private person making such an arrest shall, without necessary delay, take the arrested person before a magistrate or deliver the arrested person to a peace officer. In order to make an arrest, a private person may use physical force, as is justifiable under ORS 161.225, use of physical force by private persons making a citizen's arrest. Used by a police officer in the performance of a legal duty or a person assisting the officer and acting under the officer's orders. If the person has committed a felony, a major crime such as arson, homicide, attempted kidnapping, assault with a weapon, and the agent saw the person do it. If the agent saw the other person attempt unsuccessfully to commit a felony, and the agent makes the arrest at once or after pursuing the person. If a felony has been committed and the agent has probable cause, reasonable grounds, for thinking the other person did it, and, in another law, RCW 10.120.1020, paragraph A says, when necessary to protect against criminal conduct, when there is probable cause to make an arrest, effect an arrest, or prevent an escape, as defined under Chapter 9. For example, an armed security agent on an outdoor plant patrol gets a radio message that the cashier's office has just been robbed at gunpoint by a tall, bald, mustachioed man in a Navy pea jacket. The agent sees an individual of that description hurrying through the plant door. The officer would have good probable cause to arrest the man, although his wisdom could be questioned since he'd been told the robber was armed. Additionally, it would be extremely unwise for an unarmed officer to attempt to make the arrest. If the other person, in the agent's presence, is committing a breach of the peace or is about to renew on, is drunk, for example, or is trying to obstruct the normal functioning of the workplace. If security agents make the arrest, they should be prepared to substantiate that at least one of the above apply. All of the above laws mention probable cause. What does that mean? Definition of probable cause. That set of facts or apparent facts that would cause a reasonably prudent person to conclude that the crime has either been or is being committed, and that this is the individual who either committed the crime or who is committing the crime. Requires more than 50% certainty. In other words, more likely than not. Anyone who watches police movies or TV shows knows that police, when they arrest a person, must read him his rights. As a result of the 1966 U.S. Supreme Court decision Miranda versus Arizona, police must inform a suspect that he has the right to remain silent. He does not have to answer any questions. If he does answer questions, His answers may be used as evidence against him. He has the right to consult with an attorney before or during questioning. If he cannot afford an attorney, one will be provided for him without cost. The requirement to read a suspect his or her Miranda rights does not apply to private security personnel unless the private security person was functioning as an instrument of the police. The phrase, unless the private person was functioning as an instrument of the police, is critical. A security agent making an arrest with no more authority than that of a private citizen does not have to read the subject their Miranda rights. However, if the security agent is deputized, is a special police officer, or an off-duty police officer, Miranda must be given. It's important to note that aiding a police officer pursuant to his request does not constitute being deputized. In fact, ORS 162.245 says it is an offense to refuse to assist an officer in Oregon. Detention. Security agents should leave decisions about detaining a criminal suspect to the management of the security department or company. But if for some reason that is not possible, agents should know the following guidelines for detention. The same probable cause as an arrest. The same requirements as applies to an arrest applies to detention. Agent must have reasonable grounds for supposing the suspect to be guilty of some offense. The agent's supposition may later turn out to be incorrect, but as long as probable cause existed, the agent and the organization should not be liable on that score. Privacy. The suspect should be detained away from the vision and hearing of others so that no complaint of slander or humiliation can be made. Detained on the premises. The subject should be detained on the organization's property, not at some off-site. He should be detained under reasonable conditions. Should not be subjected to any harsh or unreasonable conditions of detention, such as tied to a chair, for an example, or made to sit in an unheated room in winter, or held in an arm lock. It must be for a reasonable time. Security personnel should make the decision quickly to arrest or not arrest. Washington states it this way: RCW 4.24.220, action for being detained on mercantile establishment premises for investigation. Reasonable grounds is as defense. Reasonable grounds, that set of specifics, articulatable facts that would cause a reasonable, prudent person to believe that a crime either has been or is being, or is about to be committed, and that the person who's committed it is about to commit the crime. In any civil action brought by reason of a person having been detained or in the immediate vicinity of the premises of a mercantile establishment for the purpose of investigation or questioning as to the ownership of the merchandise, it shall be a defense of such action that the person was detained in a reasonable manner and for not more than a reasonable time to permit such investigation or questioning by a peace officer or the owner of the mercantile establishment, his or her authorized employee or agent, and that such peace officer, owner, employee, or agent had reasonable cause to believe that the person so detained was committing or attempting to commit larceny or shoplifting on such premises of such merchandise. As used in this section, reasonable grounds shall include but not be limited to knowledge that a person has concealed possession of an unpurchased merchandise of a mercantile establishment, and a reasonable time shall mean that the time necessary to person detained to make a statement or to refuse to make a statement, and the time necessary to examine employees and records of the mercantile establishment relative to the ownership of the merchandise. Let's discuss use of force. When to use force, how much force to use are critical questions for security agents. When necessary, by a public officer in the performance of a legal duty, or a person assisting the officer and acting under the officer's direction, or when necessary by a person arresting one who has committed a felony and delivering him to a public officer competent to receive him into custody. By a party about to be injured, or by another lawfully aiding him in preventing an offense against him when the force is not more than necessary. To detain someone who enters or remains unlawfully in a building or on real property not open to the public. To prevent a mentally ill, mentally incompetent, or mentally disabled person from committing an act dangerous to any person, or in enforcing necessary restraint for the protection or restoration to health of that person. How much force can be used? It depends on the situation, and only that necessary to control and terminate unlawful resistance, and to prevent the commission of a serious offense involving violence and threatening death or serious bodily harm. As a rule of thumb, reasonable and necessary force can be used to make a lawful arrest. However, remember, if the arrest is unlawful, any force used is unreasonable. And to defend or regain personal property. Consider this situation. A security officer observes a frail older female employee slipping one of the company's products, a telephone, into her purse. The agent approaches the woman, informs her that she is under arrest, and tries to wrench the woman's pocketbook from her grasp. In the struggle, 2 fingers on the woman's right hand are broken. Was excessive force used? A court would probably say yes. It was not necessary for the agent to tear the purse away from the woman. The telephone could have been recovered later. Now consider this situation. A female store employee observes a man slip a billfold into his pocket without paying for it. The employee approaches the man and informs him he's under arrest. Instead of submitting, the man knocks the employee to the floor and tries to leave the store. A store security guard observes the incident and tackles the man before he can escape. The subject falls against a display table, knocking out several teeth. Was excessive force used? Probably not. The security officer used only that amount of force necessary to make the arrest for assault and recover the stolen property. The key words in both of these cases, and in similar real-life situations, are reasonable and necessary. In the first situation, the subject was a frail older woman and unlikely to resist the security officer and posing little threat even if she did resist. In the second situation, however, the suspect was a man who had already demonstrated a willingness to use force to avoid arrest. Escalation of use of force. Here are some things security agents should consider when deciding whether or not to use force and how much force to use. First, is the subject resisting arrest? Is he compliant? Verbal commands. Passive resistance? Contact controls. Active resistance? Hard controls. If he's assaultive, again, hard controls. If he's using assault with a deadly force, then use of deadly force is authorized. We also must consider what are the relative physical capabilities of those involved. An elderly man or a pregnant woman is unlikely to require much force to subdue. On the other hand, a husky teenage boy could be a formidable opponent and should be approached with caution. If the subject has a weapon, how much threat does it pose? A man who strikes with his fist is less dangerous than a man with a knife. What is excessive force in the first case may not be excessive in the second. What is the behavior of the subject? Any force used on someone who surrenders peacefully may be excessive. What are the different methods of force? Verbal commands, physical apprehension and restraint techniques, handcuffs, riot control agents, RCA, batons, non-lethal weapons, or firearms. What is deadly force? Deadly force is defined as a force which a person uses when he knows or should know would cause substantial risk of death or serious bodily harm. The right to use deadly force is closely linked to the right of self-defense. In other words, a weapon likely to cause death or serious injury should only be used if the agent's life or the lives of others are threatened. Deadly force cannot be used solely to defend property. For example, if a thief is fleeing from a store or a house with stolen goods, deadly force is not justified. Many authorities hold that even when an arrest is being made, deadly force should be justified only if it's under conditions of extreme necessity, as a last resort, when all lesser means have failed or are not reasonably available. This means the arrest is for a felony and the person making the arrest is a peace officer or is assisting a police officer, and the person believes that using deadly force poses no substantial risk or injury to an innocent person, and the crime for which the arrest is made involved the use or threatened the use of deadly force, and there is substantial risk that the person to be arrested will cause death or serious bodily harm if his apprehension is delayed. Notice that all these conditions must be met for the use of deadly force can be justified in the course of making an arrest. In other words, agents should do everything possible to avoid using deadly force. If necessary, the agent should retreat. If an assailant has a deadly weapon or retreat is impossible, the agent should warn the assailant that he, the agent, has a weapon and intends to use it to defend himself and others. Search and seizure. The Fourth Amendment to the U.S. Constitution protects people against unreasonable search and seizure. If security agents search a person or confiscate some item in the person's possession, and a court later judges their actions to be unreasonable, two bad outcomes can happen. The item seized can be thrown out as evidence in a criminal prosecution. This is called the fruit of the poisonous tree defense. And the agent and or the company may be successfully sued. Clearly then, security agents need to be sure that any search they make of people or their property and any seizure of items is reasonable. But what is reasonable? Probable cause. The agent must have probable cause or reasonable grounds for wanting to make the search. If an agent frisks an employee for a weapon simply because he dislikes and wants to harass the employee, legal trouble will probably not be far behind. An agent must have plausible cause for supposing that a search might yield something, as for example in a situation where the agent has received a tip from another employee that the first employee was carrying a gun, or whether the employee or the officer spotted a bulge seemingly in the shape of a gun in the employee's pocket. You must ask consent. The agent should ask for the other person's consent to search. If the person consents, then the agent and the organization are clear of liability as long as the search is reasonably conducted and the employee has not been coerced or intimidated into consenting. In practical fact, most people will say yes to a polite request to search. Ask in private. When an agent asks for an employee's consent to be searched, he or she should do so out of sight and earshot of other employees. Otherwise, the request itself could be legally interpreted as an accusation of guilt and could lead to a lawsuit for slander. It should be noted that the above does not apply if your organization's employees sign a pre-employment agreement that the company has the right to search their persons and their property at the company's discretion. This is similar to the ability of the military to search any vehicle entering or leaving a base. Consent is implied and reinforced by signs at the entrance. There must be reasonableness in searching. The agent should not go to unjustifiable extremes in searching a suspect's person or property. For example, as an agent may ask an employee to unlock his car to permit a car search, but the officer should not smash the vehicle's window to gain entry or pry a trunk open with a crowbar. Likewise, when searching a person's backpack, purse, or the like, an agent should have the person open the bag and move anything which needs to be moved so that the agent can see any contraband. This policy applies also when searching a vehicle with probable cause and have the driver open the trunk and so on. Lockers and desks. Can security agents search an employee's locker without an employee's consent? Case law has established that if the organization provides a lockable locker but retains the combination, the duplicate key or master key with the employee's knowledge, then the organization has the right to enter the locket at its own discretion. If that is not the case, for example, the employee provides his own lock and key, then the interior of the locker will probably be viewed as the employee's private property. If that's the case, and if security agents suspect that some incriminating material may be inside the locker, the security department would be wise to call in the police and let them decide whether to obtain a search warrant. Case law has established that the interior of a desk will probably be viewed as an agent's private property if the organization has assigned the desk to that person alone. If more than one employee uses the desk, security agents can search it at will. Seizure. There are certain things that security agents can confiscate from a suspect and hand over to police without having to fear legal consequences. Any item of company property that the person can reasonably suppose to be in the act of stealing. Any instruments used in committing a crime, for example, a gun used in shooting someone or committing a robbery. Any contraband, that is narcotics, deadly weapons, or counterfeit money. Agents cannot safely confiscate items just as a matter of personal conviction. For example, the officer should not rip a nude pin-up poster off the inside of an employee's locker on the grounds that you shouldn't have that filth here. Must be in plain view. Case law has pretty well plain view. Case law has pretty well established that incriminating items such as contraband or evidence of crimes can be seized whether or not they are on a suspect's private property, as long as they were within plain view of the person doing the seizing. For example, if a security agent walks by an employee's open locker and sees a glassine envelope of what is suspected to have cocaine inside, he or she can safely confiscate the envelope and hand it over to the authorities, even if the locker had the employee's lock dangling on the hasp. It must be on the premises only. Security agents should engage in search and seizure activities only within the employer's plant or property. If a subject is on the street outside the business establishment or down at the corner tavern, hands off. Interrogation. When security agents take a suspect into custody, they are best advised to let the management personnel of the security department do any necessary questioning of the suspect prior to calling police or releasing the suspect. If, for any reason, that is not possible, however, agents should know these guidelines. No Miranda. As long as the security agents are private citizens, there's no specially conferred powers or police status. They do not need to read Miranda rights to the suspect. A confession from the suspect will not be rendered inadmissible just because the rights were not read. However, as we mentioned, if the security agent is a moonlighting police officer or any other specially licensed or deputized officer, he or she should read the rights to the suspect. Voluntariness. To be admissible in court, any confession must be voluntarily given. That is, it must not have been extracted from the suspect by threats, intimidation, or physical force. The security agent should ask himself or herself, is what I plan to say or do likely to cause an innocent person to confess? If that's remotely possible, then the answer could be yes. The agent should not do whatever he or she was planning. Should be done in privacy unless with the opposite sex. Questioning should be in private so that the suspect cannot claim humiliation, slander, or any other offense. One important exception occurs when the security agent is a man and the suspect is a woman. In that case, the agent should have another security staff member, preferably a woman, present as a witness. That way, the suspect cannot claim that the officer committed any sexual impropriety. Recording by notes of a person's confession will be admissible in prosecution. However, security personnel like to have the backup assurance of having the suspect's confession preserved in more durable form. Tape or recording by notes of a suspect's confession will be admissible in prosecution. Often, however, security personnel like to have the backup assurance of having the suspect's confession preserved in a more durable form. In most cases, tape or other recording is not advisable. Many states disallow recorded confessions as evidence. An agent should learn what the relevant law says in his or her state. In Oregon, whether or not the recording would be admissible is difficult to determine. Anything presented in court needs to comply with the rules of evidence, and in many cases, pre-recorded conversation will not make the cut. One big reason is the hearsay rule. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted therein. Oregon's evidence rules generally prohibits hearsay statements in civil and criminal trials. A written confession is a good idea. Great idea to put the confession in writing, have it signed by the suspect. In their book, Protective Security Law, Butterworth, 1983, Fred E. Inbaugh, Martin E. Aspen, and James E. Spioto say the preferred practice is to have a stenographer present who will preserve, in shorthand or stenotype, the questions asked by the interrogator and the answers given by the confessor. Then, after what has been said has been typed up, the transcript should be read by the confessor or be read to him as he follows the typed materials being read. Then he should be requested to put his name at the end of it and initial each page. During this period, there need be no witnesses present, although it is advisable to have the confessor soon thereafter acknowledge his statement in the possession of another person or two. To submit your quiz and your exam, open a Word document, type your answers on the Word document and save it, attach the document to the email and send it to the operations manager and the CEO. These are the questions for your review quiz. Once you have completed your review quiz, you may proceed to your end of course exam.